joined today by my colleagues from the region who include Gail Callender from CUSCAP, Kenisha Hewitt from JCAP, Vanessa Mortley from ECHO, and Adana Stafford from CUT. Feel free to use the Q&A or the chat feature for any questions that you may have, and we will be stopping at intervals to respond to some of your questions and also at the end of the presentation. So I'm going to be sharing my screen and beginning the presentation at this time. So let us begin by looking at ACCS. The Association of Caribbean Copyright Societies was founded in 2000 and seeks to promote and protect the interests of copyright owners and the regional creative industries. ACCS acts as a centralized negotiation and licensing system for its members and undertakes lobbying and advocacy activities. ACCS has been aggressively working on negotiating digital licenses with various regional and international digital service providers, while simultaneously strengthening regional partnerships to ensure that members are better able to collect royalties from the local, regional, and international market. The founding members of ACCS are the Copyright Music Organization of Trinidad and Tobago, COT, Jamaican Association of Composers, Authors, and Publishers, JCAP, the Copyright Society of Composers, Authors, and Publishers Incorporated, CUSCAP, the Eastern Caribbean Copyright Collective Organization for Music Rights, ECHO, and there is an associate member, BISCAP, the Belizean Society of Composers, Authors, and Publishers. To date, Access has over 10,000 members in the various categories: performers, producers, writers, and publishers. Please note that membership is only open to societies and not individuals. We now look at the ACCS directory. Once you are on the site, you will be able to browse the directory and search for members by society, genre, country, name, and their role or membership category. Also, the ACCS website provides updates about various activities taking place and includes additional information about the history and structure of our association, and the link is accscaribbean.com. So at this time, I want to see if there are any questions before we continue with our next presenter. Thank you. All right, seems as though there are no questions at this time. Let me introduce our next presenter, Kenisha Hewitt, Operations Manager from JCAP in Jamaica. Kenisha.
Thank you, Melissa. Now let us look at some rights that are important to consider when keeping musical events. After all, this is why we're here. The first right we will look at is copyright. Now, what is copyright? Copyright, this is a bunch of rights granted to authors of original works Example, writers, musicians, artists, poets, painters, film, technology-based works, such as computer programs and electronic databases, and other creators which provide protection over their work. Copyright is automatic, right? It's automatic in musical and literary works, provided that it meets the eligibility criteria. And these are: one, the work must be original, not a copy from another work or not somebody's work that you are using as your own. And two, it must be in a physical format. That is, it's either written in a tangible manner, like a book, or on a CD or a tape, right? And the way in which the world is going, we might have to find other ways of having it in a tangible form. Now, copyright protection lasts for the lifetime of the author plus 50 years in some countries. But in other countries and other jurisdictions, it goes all the way up to 95 years. Let us look at another right, and this is neighboring rights. Now, neighboring rights is also referred to as related rights. It protects the rights of the performers, broadcasting organization, and producers of phonograms. Phonograms are sound recordings such as audio tapes, records, or CDs. You would have heard Melissa from BaseCap mention CMOs, which are members of ACCS. Now, what is a CMO? Well, a CMO is an organization that exists to administer the rights of copyright holders, such as songwriters, publishers, and related rights holders, such as performers, producers of sound recording. Under law, holders are granted a bundle of rights, including the right to copy, the right to distribute the work, the right to publicly perform the work, and the right to broadcast the work. The rights granted are exclusive, which means that you must have the permission of the owner of the copyright to use his or her creation. There are over 230 author societies in over 120 countries for copyright and 57 related rights globally. These organizations, under a network of reciprocal agreements, such as ACCS, is able to represent rights holders from Spain, for example, in the Caribbean, and vice versa. Finally, the core activity of a CMO is that of rights management. This includes licensing the rights on behalf of the rights holders, such as members and affiliates, monitoring music use, where and what music is used, negotiating fees using tariffs, collecting the money and distributing for the rights holders. While users engage with CMOs as a one-stop shop to access worldwide repertoire, these are some of the ways in which CMOs are there for rights holders and users. Thank you.
Okay, thank you so much, Kanisha, for highlighting some of the key terms in relation to IP, intellectual property, and copyright, as well as the role of a CMO. We will now move on to Adana Stafford, who is the Supervisor of Licensing and the Revenue Department from COT in Trinidad and Tobago. Adana?
Thank you, Melissa, and good morning, everyone. Let's discuss who requires a license or permit. A license or permit is required for the public performance of copyright music at an event or business where music is performed. So if you are planning to produce an event, example, having a fete, then you could not possibly approach all of the copyright owners for the music you will play. In such situations, CMOs exist to assist those who require a license from its members or international affiliates. Under the law, a license is required for the public performance of music. Public meaning outside of your normal domestic environment. Why pay for a license to play music in public? One of the main means by which the owners of the rights in a song earn income is through the royalties paid for the public performance of their work. As a result of the effort expended in the creative process and the importance of creative activity in economic, social, and cultural development, the creators of artistic works, including music, and those who finance and commercialize these works under the Copyright Act, are entitled to be compensated for the use of their music, including when it is played in public. Consider some of the benefits you derive from the use of music. One, it directly earns revenue, for example, when used in nightclubs and performed at concerts. Two, it is used as an amenity to attract clientele, for example, performances in hotels. And three, it provides ambience which encourages employees to be more productive and provides for more attractive premises, for example, in shops, offices, and restaurants. The process. The individual or promoter would make an application to the CMO providing details with respect to the event. That is the venue, date, admission fee, capacity of the venue, and the number of tickets printed, as well as the music which will be performed. The application will be processed and the promoter will be provided with a quotation. And upon payment, the license will then be executed and a receipt as well as an invoice will be provided to you. Licensees should note that a requirement of the license is that access to the event should be given to the CMO's representative and a running order of the music performed should be provided. This information enables the CMO to distribute royalties more accurately to the owners of the music used. The society would issue a blanket license which will allow the individual or promoter to use all the music in the CMO's repertoire. Thank you.
Thank you, Adana. I see that we have a question. How does a license apply to virtual or digital events? Okay, so we're going to be addressing this question in the next part of the presentation. So are we going to do the poll at this time, Gail?
We'll complete it after Vanessa's presentation.
Okay, excellent. So we move on to our next presenter, who is Vanessa Morton from ECHO. And Vanessa is the operations manager. So Vanessa, go ahead.
Thank you, Melissa. Good morning, everyone. Today we're going to, well, for my presentation, I will be going into tariffs. The tariffs are documents used by CMOs to establish the framework for pricing its licensees. These tariffs are based on CSAC guidelines to set up the structure for pricing of the licenses and permits. CSAC is the International Confederation for Societies of Authors and Composers, and that body ensures that CMOs operate according to best practices in the industry. The CMO issues annual licenses as well as permits. However, today the focus will be on single events, and I will take you through two scenarios in respect to single event licenses. Okay, so in scenario one, promoter one applies for a license. The details of the application are that it's a line, the admission is free, the expected attendance is 100 persons, and the type of music is recorded music. The CMO would then look at its tariffs and choose the one which deals with free events. They would then provide you with a quotation. In the example here, the tariff would be based on the capacity, which is 100 persons, and the corresponding fee would apply. In scenario two, promoter two applies for a license. The details are that the event is a concert with an admission fee of $80 and an expected attendance of 5,000 persons. The type of music that will be used will be both live and recorded. The CMO again will look at its tariff which deals with concerts and will provide a quotation. In the example here, the tariff would be a percentage of your gross receipts. So it would be calculated such that, for example, if say, for example, Society X, the tariff is 5%, then it would be 5% of your $80 for the ticket price, the 5,000 persons which you're expecting. That would be $20,000. So therefore, the license fee that you would be required to pay is $20,000. If society-wise tariff is 8%, the calculations would be such that, sorry, it would be $80 again, which is your admission fee, by the 5,000 persons that you're expecting to attend, and then it would be 8% of that, and the license fee therefore would be $32,000. In each of the events scenarios shown before, you would require basically 2 licenses, one for the clearance of the copyright and the other for the clearance of the neighboring rights that exist in the performances. In countries like Barbados and Trinidad, the CMO, COSCAP, COT can actually provide clearance for both rights, whereas in other countries such as Jamaica, the CMO, JCAP, would be able to provide clearance for the copyright, and JAMS would be able to provide clearance for the neighboring rights. We have looked at examples of when you do need a license. However, there are a couple of instances where a license is not required. If you're using music that is in the public domain, that means the copyright has expired, as explained by Kenisha. Some last up, well, the least is up until 50 years after the death of the last living creator on the work, and in some countries it could go up to 95 years. And if the music is used in your domestic environment, like your home, then you would not need to get a license for that. Yeah. Okay, so you have paid for your license, and now you're wondering, well, how does the CMO know who to pay? CMOs pay out royalties by way of distribution. A distribution is a process by which the revenue collected is shared among the membership. And the membership is not limited to just your local, it would be regional and international, because we have reciprocal agreements with other societies and we represent their members as well. In order for the CMO to do that, the CMO needs to first collect the license fees from the music user, whether it be you, the promoter, a broadcaster, premises, etc. Then the CMO needs the performance logs from the event, and the members also have to provide details. They could provide details of their performances if the promoter doesn't. And the CMO also needs information pertaining to the songs performed in its systems to be able to make a payout. So if song X is performed at your event, it is registered with the CMO. The CMO has received payment for that event. Therefore, the shareholders on that song would receive royalties for that performance. Thank you. That's it for me.
Okay, thank you so much, Vanessa. We will now move on to Gail Callender. Gail is the operations manager from COSCAP. And before she begins her presentation, she will be doing a poll. So go ahead, Gail.
Hi, good morning. Prior to doing the poll, we have one question. And the person asks, what about NGOs? For registered charities, and I'm going to speak specifically about Barbados, they are exempted under specific circumstances under the Copyright Act. And that will be a case where they're only using recorded music. And remember, I'm speaking specifically about Barbados. Okay, to ensure that you're not falling asleep on us, I'm going to launch a poll. And the question is, what does copyright protect? Is it an idea, lyrics, a book, or an invention? Okay, we have some answers, and based on our answers, it seems like you were paying close attention. I have one person saying copyright protects, and sorry, two persons indicating that copyright protects an idea. Remember, the criteria for meeting copyright is that one, it must be an original, and two, it must be in a tangible format. So an idea, of course, is not in a tangible format. So that would not apply in this instance. And the second question, who is granted rights under neighboring rights or related rights? And we have a few right answers, and then we have a couple wrong answers. And I'll go through this question. Neighboring rights or related rights protects the rights of the performer, whether it be the main artist, session musicians, background vocalists, and the record label or the executive producer, that being the person or entity who pays or finances the recording. So in this instance, it will not be the publisher or the composer or author, as these persons will be protected under copyright. So we're going to end the poll at this time, and well, this particular poll, and we're going to start a second poll. I'm sorry, currently experiencing some technical difficulties, but we will launch that poll prior to closing off the session. And my topic today is online licensing. And we all know that COVID-19 has dealt a strong blow to economies all around the world. And this is no different to the Caribbean music industry. In responding to this pandemic, the industry has had to relook how it operates. As we're well aware, during the lockdown of borders and the implementation of social distancing, several events have been canceled. But also during this time, we have seen the emergence of several online events as artists, DJs, and event promoters have taken the opportunity to be creative and host online events in order to make up for lost income, raise funds for charities and frontline workers, as well as to keep their fan base. When music is streamed online, the rights of the authors and publishers, as well as those of the owner of the song recording, need to be licensed. And how does these events affect the CMO? The CMO generally administers the online rights of the authors and publishers, so a license would be required. However, if the platform has a blanket license with the CMO, then a separate license is not required for each event unless they are monetized. And what do we mean when we say monetized? Is there a paying audience? That is the user paying for this to see the specific event? The other questions are donations being solicited? Now, there may be no fee to see the event or is being charged. However, you, the audience, are asked to give generously. And the third question is there a sponsor? This can, however, further be complicated by the fact that the rights in the song recording, especially for non-regional music use, is often administered directly, and I said directly, by the owners of the song recorded. And a license must be obtained from them, so that if you have a license from your local CMO, there is still the risk that the music use can be blocked where international song recordings are used. So remember, if you're using international song recordings on your stream, then you need to obtain a license from the owners of the master recording, that being the persons or entities who finance the recording. And this license, again, is obtained directly from them with respect to the international repertoire. You might have also heard of the new ACCS initiative called C-Note. And this aims to improve access to Caribbean music of all genres while clearing all the rights in one location. So we have a scenario for you. So it's on screen. Big Rock Promotions is promoting a concert with several regional artists. The admission fee is $100 with an expected attendance for this event of $5,000. This show will take place in several Caribbean territories, and the event will have live music and DJ performances. So what would be required? First and foremost, Big Rock Promotions need to apply to each society in the territory for which he intends to have the event. So for example, he's having the event in Barbados, St. Lucia, and Belize. So he needs to apply to COSCAP, ECHO, and BASECAP separately to obtain the license. The admission fee will be calculated based on, the license fee will be calculated based on the particulars which he is given. So in this instance, it's $100 with an attendance of 5,000 persons. So as Vanessa calculated earlier today, you would take the admission costs, multiply by the attendance to get the revenue, and depending on the rate the society charges, then he would pay the required price. Now, when he pays the license fees, he will be provided with a contract. And this contract will also indicate that he would be required to provide access to the society's agent in order to verify the numbers, and he will also be required to provide the set list for the live performances to the society. Second scenario, Big Rock Promotions has now decided to record the show to place it on a digital platform where persons are able to download the concert online. And what would be required in this instance? First and foremost, Big Rock should ask of the performers, ask the permission of the performers, to record their performance. And he should get this in writing. He's, as indicated earlier, he's to obtain the public performance license from the societies. He should also obtain a synchronization license from the society and an online music license. And in this instance, he has also used some international, the DJs also use international music for the event. And permission should be obtained from the owners of the record label, which would be the owners in the song recording, if the platform does not have a license with them. And the question always is, and as I indicated earlier, why would my event be pulled down or muted? And this would be in the case where you do not have the correct permissions from the rights owners or the licenses from the CMOs to have the event. And I'll check the chat and the Q&A for a few questions at this time. Okay. We have one question. Does each organization determine its own rate, or is there a general range agreed among the various organizations? Well, as indicated earlier, the tariffs, which are the guidelines for which the license fees are charged, are based on CSAT guidelines. And in that instance, there's generally a range. On this panel today, we have some societies which only collect copyright, and others collect both copyright and neighboring right. And there's where you would see a vast difference in the rates being charged, because some societies are charging for 2 rights while others are charging for 1. Okay, another question is, to what degree is the monitoring of compliance effective? Are there events that have occurred without licenses, and what are the penalties? Okay, I'm going to speak with respect to Barbados. After I'm finished, I don't know if any of my colleagues would want to jump in. Yes, there have been instances where an event has taken place without the necessary license. And what we do here is we monitor social media platforms and check the newspapers, etc., to see what events are taking place. If you're having an event, the promoter of the event is responsible for taking out the license. But if you wish to take the matter to court, in addition to the promoter of the event, the owner of the venue is also held liable. So if we see that an event is going to take place and the person hasn't come in by a certain time, what we would do is contact the owner of the venue to inform them of their liability. And usually someone will come in and take out the license. I don't know if any of my colleagues would want to respond.
It is similar for us in Jamaica also. But what happens if the event is held without that license, then we go ahead through the legal system, because persons should be aware that using persons' intellectual property without the correct permission is something that should not happen. So we try to do similar to what CASCAP has done, where we ask the organizers to come in, we contact the venue operators also before the event. But if there are some that have decided that, okay, this is not important and still go ahead with the event, then we can take them to court and follow the necessary procedure thereafter.
Okay, well, for ECHO, again, it's similar to JCAP and FASCAP. However, if after the event, the person decides, the promoter decides that they are willing to, after we approach them, of course, the license fee would most likely be a bit higher than if they had gotten the permit before the event.
Okay, we have a question. Would an online license also be relevant to or cover podcasts? Yes, if you're using music in the podcast, you would need the license. Another question, they're coming fast. What are the requirements of churches using music, such as hymns, recorded music, snippets for masses? Again, I'm going to speak to Barbados, where if the music is being used in the actual mass, you would not require to acquire a license. Any of my colleagues?
Yes, if you are using music for your regular church service, your worship, then there is no license required. However, if you're having an event inside of your church, then you would need the license. Or if you're having, it could be like a crusade, anything outside of the church, you would still need to get that license. But once it's your regular mass, there would be no license required. Okay, there is another question. How does one guesstimate the likely funds to be raised through actual remittances? Pledges do not always manifest into actual funds received.
I am assuming that you're speaking to online licensing, and you will be required to provide that information. You'll be required to pay a deposit, and then you would reconcile afterwards. Another question is there a way to get a list of contacts for all panelists on here? Yes, I will type that in the chat for you. I'm going to ask one of my colleagues to continue with the questions, please, while I type.
Okay, are royalties paid within the same year, for example, for performances by an artist during this year? Would the royalties be paid this year or next year? I can speak to, for in our case, as it relates to ECHO, it would be paid in the following year. It would not be the same year of the performance. Anybody else wants to respond?
It's the same for JCAP. So we would, whatever we collect in this year would be paid out in the following year.
Okay, with respect to Barbados, royalties are paid 1 year after the collection. And this is generally so for most societies around the world. What happens here is that for events which we consider to be major shows, which are events grossing over $5,000 in royalties, those are paid in a separate distribution. But what happens is that we often ask for a deposit on the license, and then after the event has been completed, we ask the promoter to provide the reconciliation from the Barbados Revenue Authority, and then we pay if there was more in attendance than had the quotation was based for, the person would pay the difference. If they had a fall in the expected attendance, if need be, we would issue a refund. And sometimes this takes a while for the Barbados Revenue Authority to provide the figures for them. So generally, we hope to pay the royalties for a live event grossing over $5,000 within 3 months, but often this doesn't happen in that time frame.
Okay, another question. If performers provide their service as a donation, playing their own music, performing their own works, are there any other requirements of the host apart from getting a written permission?
Could you repeat that question again?
If performers provide their service as a donation, playing their own music, performing their own works, are there any other requirements of the host apart from getting a written permission?
First and foremost, when persons sign the agreement with the CMO, and I'm speaking to Barbados, of course, they sign an exclusive agreement with the society. So if you wish to use copyrighted music, as the Copyright Act says, in a public place, you're required to get permission. And because they've signed that exclusive agreement, they cannot give you the permission themselves. You have to come to the CMO, who would then charge you a license for that event. Or dependent, let's say it's for a charity, we will give some consideration to waiving the license.
This is similar for JCAP also. But in how many cases do you have a particular performer that is solely the creator for a particular work? There are instances where there are many persons that are involved in one particular song. No, you would have to get permission from each individual of that particular work for it to be cleared. And that sometimes is quite difficult. So it would be best if you go to your local CMO first.
It is similar for us here in Belize, as what my colleagues had mentioned.
It is similar for for all the right owners permission via a letter. So it's similar to the other organizations.
Okay, we have somebody asking whether the webinar will be available to look over after it's done.
Yes, it will be. Kindly look for it on the Access website.
Okay, there's the next question. I understand the tariff explanation. Can you give an example of how the money is collected from an event is tabulated for royalty disbursement to the performer rights holders? In other words, an example using figures, money from that particular event that is then disbursed as royalties. Okay, so in the example that we had, the promoter paid $20,000 for his event. The society would then have to recover its running costs, which we call our admin expense. So let's say our admin cost is 10%. Okay, I'll use a 30%, 20,000 by 30%. So 6,000 goes to the CMO in order to pay the persons who licensed the event, all the other overhead that would be incurred by the society. So therefore, we are left with $14,000 to distribute to the songs that were performed at the event. So let's say there were, from the playlist that we received, it has 1,000 works performed, right? So we have $16,000 to be divided among the 1,000 works that we have from our playlist. So each song would then be valued at, well, each play at that event would be valued at $16 each. Now that $16 has to then be further broken down to the shareholders on that song, whether it be, so whoever the writer is, the author is. So if the song has 4 contributors, 2 lyricists and 2 composers, and the share is 25% each, then the $16 would then be 25% to each person divided by 25%. So each shareholder on there would be $4 per the performance of the song. That's the simplest way I could think of putting it. Obviously, there are other things to factor in. That would have been a calculation based on just one right, whether it's if it's just the copyright. So I just spoke about the author and the composer. However, if there was collections for related rights, then obviously there would be some calculations that would involve the performer and the producer on that work. Anybody else wants to add to that?
That's fine.
Okay, I hope that helped answer the question. Another question, why has broadcast revenue fallen off the 2019 annual report? Broadcast and cable continue to be key challenge, representing 13% of revenue in 2018 compared to 39% in 2009. Anybody want to?
I will answer this question. In the region, we continue to have problems or issues with the payments from broadcasters. And in addition, their license fees are based on advertising revenue. So if their advertising revenue is falling, we would also see a backlash from that.
Okay, any other questions? Let me see. If the promoter records the event, does the license say how many times you can rebroadcast or make available on the printer's website?
Yes, please. Information will be placed in the contract.
If a public outdoor performance is watched out before the event has started, is the promoter refunded his licensing fee? From an ECHO standpoint, we deal with it in 2 ways. The promoter can get a refund, but we also allow the option of crediting the account. So if they reschedule the event or that of anything of that sort, then it would be applied to that new date if it's rescheduled.
That is the same for JCAP.
Yeah. Same procedure for cut, either refund or credited to the account for a next event.
That would make it similar for everyone in the region.
Next question, if broadcasters are non-compliant, what do you do about it? And is it credible that advertising revenue has fallen? If they are non-compliant, we always try to go the route of talking to them, but we have the option of going through the courts, filing claims for copyright infringements, etc., in order to get them compliant. And for our territories, it is credible that advertising revenue has fallen because there has been a saturation of radios, well, broadcasters in the region, and the competition has had these broadcasters having to review and provide advertising rates that are a little bit lower than what it was, say, 2009.
In addition to that, you would find that lots of persons are now advertising on social media platforms.
We have another question. What is the position of government broadcasting entities who use music in their programs? Is there a standard for the duration of music use, example as background or effects in features?
It is not standard. It would vary, and of course, the government would have to pay for the use of music as well.
Yes, there is no standard as for the duration of music used. The license would obviously be a blanket license. So once the government pays for their license, there will be no standard as to the duration of music used, whether it's in background or effects.
We have to remember that these music are creators. Their intellectual property is being used, whether government, whether charity, their livelihood. This is what some of them use as their livelihood, right? To make a living. So they have to be compensated. We would rather sitting at a table and having the discussion than to go through the courts. So we would prefer, and we are open to discuss with any music users, any promoters, any organizers who wants to use music to come in, sit with us and have that discussion, because persons' rights are being used and they must be compensated.
Okay, we have a question for the online licensing. DJs who live stream on social media platforms to entertain their followers, are they required to obtain licenses? Gail?
They would be required to obtain a license for the use of the sound recordings. And as stated previously, this would be obtained from the record labels. And if the platform has a license with the record labels, then it would not be required for that specific event.
All right, another question. Tell me about a national event like carnival competitions where the festival organization pays the competitors based on a contract. National events as Carnival, it's an event like any other event. So the works being used is what is being licensed and not necessarily, it doesn't, there's no tie between the fact that the competitors are being paid based on contract. The license covers the public performance of the works at the event. Um, so you would require the same rules apply for Carnival or any other national event. Anybody else wants to add? All right, there's another question. When music is streamed on Spotify and similar platforms, do you have to claim, or does the streamer volunteer the royalty, and is this audited?
The platform would provide the information on what was streamed to the CMO, which issued the license.
Okay, another question. We are aspiring for more local content on radio stations. If that should happen, should the local artist see an upsurge in his or her royalties? Guaranteed. Once the radio stations are licensed and are paying a license fee, then whatever is played is what will be paid for. So if there is more local content and those persons are part of a CMO and their works are registered with a CMO, once the society has revenue from those representing those plays, then they would see an increase. I'm not sure about upsurge, but there would be an increase in the royalties that they receive once their work is performed on a licensed radio station.
What is important here, though, is that the information is included in the logs provided from the radio station. Because if we receive the logs and the information is not in the logs, then you will not see that upsurge, of course.
Okay, there is a question that says, I have heard of instances as it relates to a particular IP organization collecting royalties from events, but it is not passed on to the artist. Can you speak to this? Well, I wouldn't be able to speak directly to if this happens. However, what may cause that to happen is one, the society may not represent artists and they would probably be representing the authors and composers of the works. Two, the songs performed may not have been registered. So even if the song is performed at an event and it is not registered with the CMO, the CMO would not be able to distribute to that for that performance because we have no information as to who the royalties belong to. The rights holders may also not be registered with any CMO. And also, we may not have received a complete log of the performances on that event. So if we do not have a performance log to which to pay towards, then we will not be able to pay for those performances directly for that event. There is also the fact that in our case, we pay after a certain threshold that the performance log. So after, if it's less than a certain amount that the promoter has paid, we would not have collected logs to pay directly to that event. If it's a small event, based on the amount of royalties, well, license fee they pay. Anybody else could answer the question?
Okay, what I wish to say at this time is that Well, Cost Cap in Barbados, in addition to receiving the live performances information from the promoter, or where a staff member would go and take that information themselves, we ask our members to provide us with their set lists where they perform at events. And if in an instance that the person did not receive their royalties from the event, I would suggest that they contact the society, because this is a matter that can be easily sorted if the person would reach out to the society to have the information provided to them, whether it's disputed or not. And is it, another question, is it the artist who had the artist being the performer who was making the query? Because if the performer is the person making the query, then they are paid directly by the performer the promoter when they step on that stage. What the society would be doing is paying the composer, author, or publisher of the songs performed. So if the artist is not the copyright owner of the song, he or she would not be paid by the CMO. And additionally, CMOs who are members of CSAC or IFPI must comply with certain standards. So the person who has claimed that they have not received any royalties can raise a complaint.
Okay.
1 second, please. Someone indicated that, yes, it was the performer. Well, in that instance, the performer would not be paid by the society. The society collects royalties on behalf of the performer when their works are performed by mechanical means, that is on the radio. So as a performer, when I step on that stage, I would say to the promoter, my fee is $10,000 or I'm not going on. And the agreement would be made between the performer and the promoter. The CMO would only, for a live event, would only be paying the writers, publishers, authors, composers, publishers of the songs performed, because in all instances, someone would have written the song, whether it's being played on the radio or for a live performance. And that is why those persons would join a society, because you would have an instance where I can sing really well. Vanessa has written a song for me. I go and I perform the song. I indicate what my fees are to the promoter, and I forgot all about Vanessa. So I'm making money, and Vanessa is not trickling down to Vanessa. And what Vanessa would do is join a copyright society anywhere in the world, so that when the songs I perform, whether I perform them live or they're played on the radio, she would collect royalties when that happened.
Okay, another question. Are there laws requiring presenters to get licenses from CMOs?
Presenters of what?
Well, I'm going to think that it's promoters, because it wasn't typed presenters, but since we're talking about events.
Sorry, if they're referring to promoters, then it would be the Copyright Act of each country.
Another question, how can governments help to tighten up the system? Well, governments can help by tightening, just enforcement of the legislation. That's the best way government can help. Any other suggestions, panels?
Government should pay when they're having events. They're government-owned radio stations. We need them to pay. If we can get more local music being played on the radio, we would love that as well. And the judicial process is long and tedious. If we could speed that up so that where we take a matter to court, let's say a broadcaster, it doesn't take 10 years, that would be greatly appreciated.
I want to add as well, just updates to the Copyright Act, specifically in Belize. We need the Copyright Act to be updated so that it includes, the digital environment and the new trends or the new things that are happening, so that those can be protected by our Copyright Act.
Okay, another question. What about the producers? Are they paid from the live performances fee where only the performers are booked?
Well, when you speak about the producers, are you referring to the composer of the music, or are you speaking about the person who paid to have the recording done? Okay, the person hasn't indicated as yet, but I'll expand. If we're speaking about the composer of the music, then yes, they will be paid because they would be one of the rights holder in the song. Okay, I'm going to go through a whole process here. We spoke about me being a singer and Vanessa being a songwriter. But in addition, for this example, Vanessa wrote the lyrics. We have Kenesha, who composed the music, and they have decided that they're going to split the royalties for the song called Computer, 50-50. So 50% for the composition and 50% for the lyrics. So when the song is performed live and the CMO obtains the logs for this song, when it goes into the system will pay the royalties based on the proportions provided to the CMO. So if Kenesha belongs to JCAP, when she's registering the song Computer with JCAP, she would indicate Kenesha Hewitt 50%, Vanessa Mortley 50%. And this would go into a database which, all the societies in the region use one system, and it's called COSIS. But our works in that system then go to the WID, which is the World Information Database. And that's where any society in the world can look to see what that registration is. So in the instance where there's a live performance of that song, the royalties will be split based on the information provided to the society. If we're speaking about the executive producer of the song being paid when the performer goes to perform, that would not happen because they're performing the song live. The recording of that song is not being used in that instance. So there will be no payment to the record label or executive producer.
Thank you, Gail. Another question, what if a music user blatantly tells you that they are not paying for a copyright license for radio use at their premises? I would ask Adana to answer.
Okay, well, legal proceedings is always last resort. So we seek to educate the premises owner, and if for some reason they insist, then what we do is take a sample of the music that they play and proceed with the legal proceedings.
Unfortunately, our time is running up, but I ask that you post your questions in the chat or contact the society directly with your questions. You have been a lovely audience this morning. I want you to please remember to respect the rights of copyright holders, which is the authors, publishers, artists, and record labels, so that they can continue to generate income through online streaming and musical performances. Ladies and gentlemen, thank you.